Thank you for joining us tonight. My name is Vanda Crossley. I'm with EXP Realty and Loan Factory, and I have the pleasure of introducing attorney Shema Freeman, who's an attorney as well as a realtor with EXP Realty. And so her expertise is family planning, estate planning, and so I value her opinion, and I wanted to get her on here to educate us on the things that we should be doing because we're all getting older and we need to put certain things in place for our family and our estate. And I appreciate you joining us, Shima. Take over.
Absolutely. I appreciate you having me, Vanda.
Thank you.
All right. Can I share my screen?
You should be
All
able to.
right. All right. You guys seeing my screen? Are you seeing my screen?
I was on mute, but I said
Yes,
yes.
yes, I see it.
Okay.
Mm-hmm.
Perfect. So like Vanda said, my name is Shema Freeman, and I am a estate planning and probate attorney. I'm licensed in two states, Texas and Florida. And the name of my law firm is Uritha Law, and that Uritha Law, it comes from the Swahili, it's in Swahili, it's inheritance. So that's something that's really close to my heart. And so I named my firm after two things that I love, my African heritage and inheriting and growing generational wealth. Um, Hopefully by the end of tonight or in this next 45 minutes to an hour, you'll see estate planning a little bit differently. I don't know if you were on the last call that we did, but it was more of a estate planning 101 type of talk. This talk is different. That's why I called it estate planning from birth to Medicaid. And it's actually going to walk you through what your estate plan should look like at different points of your life. And I'm not just sharing like what the documents are. We're actually going to be sharing real stories of what happens when you don't have a plan and how we can make sure that you do have a plan, and a lot of these issues that are coming up are going to be preventable. So a little bit about me. I know Vanda already kind of introduced me, but it's actually Dr. Shema T. Freeman, Esquire. I do have a PhD in material science and engineering, um, but I have long left academia and have ventured into the world of law. I actually started off as a patent attorney, and what got me into this world of estate planning is actually navigating my mom's estate and dealing with that. And as someone who is, you know, pretty smart and fairly credentialed, we thought we had a lot of this stuff figured out, and there are still things now, even almost 3 years later, that I'm still dealing with on her estate. So I've learned a lot in those 3 years, and I've kind of made it my mission to make sure that other families don't have to go through kind of the same conflict that I've been through with my family. Our mission here at UBC Law is to build, protect, and transfer. We're preserving wealth and keeping families whole. Um, so yeah, we'll get into a little bit more of what that looks like as we go through the talk. But this is our agenda. We're gonna reframe um, estate planning a little bit, but by the end of this night, you'll be able to know what estate planning is, what probate is, and then what are those critical milestones when you need to be considering either redoing your estate plan or starting one. So yeah, we'll walk through that. So like I said, we're going to do a little bit of a reframe on what estate planning is. I think most people think estate planning is just about death. And if you were on my last call, you know that we also incorporate incapacity into estate planning. So it's really about control of your assets while you're living, control over your health care if you become incapacitated, and control over who gets your assets when you pass. So think more of think estate planning is more of like it evolves with you as you continue through your lifetime. And okay, I'll show my first example. Um, who knows Prince? Raise your hand if you know who Prince is. Right? Yeah. All right. So when he passed in April of 2016, he actually left behind an estate of about $150 million, and there was no will attached to that whatsoever. So what happened was a 6-year court battle. Dozens of people came out claiming to be heirs. The state of Minnesota actually had to appoint a special administrator. There was all kinds of attorneys and accountants, and the IRS got involved. And so it eventually settled, like I said, after 6 years. But the amount of the estate had dramatically been reduced to, I believe, around $30,000 after taxes were paid and all the debts and everything attached to the estate. And I say the debts because the IRS took a huge chunk of his estate um, because there was no plan. And when I tell you a $10,000 plan could have basically stopped all of that from happening, because he could have directly activated a plan that would have said, "Hey, I want my money to go here. These are the people that are should actually inherit," and it wouldn't have been every single family member that's ever known coming to get a little piece of the estate. So before we go into what your estate plan should look like, we'll revisit what is probate. So probate is the court supervised process of settling your estate when you die. I think most people know that. Um, what happens generally is they will validate a will. They will assign an executor to your estate. That executor is named in your will. If there is not an executor named in your estate, the court will actually decide who that will is going to be. Um, they will make sure all of your debts are paid. What else what do they do? Um, that's pretty much it. I like to think of probate as a way for your creditors to get your money before your family does, which is not really what we want to happen in this world. Um, what else can I say about that? Yeah, so yeah, a will is basically a set of instructions for the court to follow in your probate process. I have another fun example of even what having a will and having it go through probate. We all know the Godfather of Soul, right? James Brown. You know who that is? So he actually had a will when he passed. And in his will, he had set aside some funds to go for scholarships for underprivileged or underserved communities in South Carolina and Georgia. But for whatever reason, his family members, he didn't have a no contest clause in his will. And so his family members decided to contest that will. Now, you heard me say that Prince's probate was 6 years. James Brown's estate probate was 15 years of probate litigation. And again, even though the charitable intentions were clearly marked out, because there were so many people that were contesting and trying to get a piece of it, the court took a lot of that money and gave it to the attorneys and everybody else that was involved. And so that's just a lesson. That's the thing to say that like just having a will is not enough. You need all the structure behind it, whether that's a trust. You need to make sure that your properties are properly titled. You need to make sure that any of your life insurance account or life insurance policies and bank accounts have a beneficiary assigned to them. So all those things work together to make sure that your estate is actually properly handled when you pass. A lot of this we've already talked about as far as why do we want to avoid probate. It costs a lot of money, takes a long time. In Texas, the average probate on the short end, 6 months, on the long end, 2 years, and that's if it's uncontested. If it's contested, again, we've already given two examples of what that looks like. It could be 10 plus years and cost a lot of money. So the costs include court costs, attorney fees, any kind of appraisal fees that we have to go into. So all of that can run maybe 3 to 8% of the gross estate. So if you're talking about a $500,000 estate, that could be around $40,000 that goes to the courts and to the attorneys and to all the other service people that are involved. And that's before your family sees anything, right? Another thing about probate, it's a public process. So the will becomes a public court document. That means anybody can look up what you owned and who you left it to. Not necessarily, a bad thing for you because obviously you've passed already, but it could leave your heirs vulnerable because then people know what they're working with. Um, the biggest thing that I've seen is why you want to avoid or probate is the conflict. You would be surprised at how, I guess, yeah, how conflict brews out of grief. So what people are angry about, and it's usually the small things, the little knickknacks, right? So as much as you can have in writing and explain it to people up front, the better, because how grief manifests itself is in this conflict when you pass. I'll give you another example. We have this woman who passed away. She all she leaves basically is a home that's worth about $320,000, a bank account. She has two adult children from different relationships, so different daddies, right? Um, she leaves a handwritten will, which actually in Texas is fine, but it has to be properly witnessed. So it requires two witnesses, and has to be notarized and all those things. So the issue with her handwritten will is it wasn't properly witnessed. So in probate court, you might as well have said, I don't have a will at all at that point. So it took about 18 months for this will to be probated, cost $28,000 in legal fees. And what ended up happening is the two children owned the house outright. Now they barely get along at this point. One wants to sell, one wants to keep it, and you have to manage that conflict. So again, the lesson in all of this is having a will that meets the state's requirements is probably the most important part of all of this, because if it doesn't meet the state requirements, then it's practically like having no will at all. So this is the estate planning life cycle we're going to go through. So from here on out, I want you to think of estate planning as more than just a one-time event. It actually evolves with your life. So we'll walk through these different stages from birth all the way down to senior planning and Medicaid. And I'll point out the important documents that you need and also what happens if you don't have your plan in place. So first up, does anybody on the call have minor children or grandchildren that are minors? Okay, a couple of you, great. So the most important thing at this stage, and I get really passionate about this because my mom and I were also foster parents at one point in our lives, and so I get particularly passionate about this because it's usually an urgent need if there is no plan. You have to have a guardianship designation for these minor children if something happens to you. Here's the issue if you don't have a guardianship designation. A judge will decide what happens to your kids. And that judge doesn't know you, they don't know your family, they don't know how you want your kids to be raised. And so the easiest way to do that is to have a guardianship designation. So it's just a one-page document that outlines who is going to be the guardian of your children if you become incapacitated or pass away. A pretty classic guardianship battle. You have a young couple, they have two kids. Let's say they're, I don't know, 4 and 7. Both parents are in a car accident together. They have no will, they have no guardianship designation. Let's say both sets of grandparents are still living. Both mom and dad's grandparents will file for guardianship. They have very different parenting styles, very different philosophies, religions, backgrounds, all that. Again, a court will decide, and that could take, a year, 2 years to decide. And in that time period, those kids are in temporary foster care. So they're just in limbo. Even though you have two sets of people that want them, they also have to go through all sorts of like doctor's appointments, psychologists, They usually will have to testify at a hearing, and I don't know how mentally capable a 4 and 7 year old are going to be at the end of that 2 years. They're going to need additional counseling just from having gone through the process. What also happens is the estate will actually pay for all of that, all those court costs and attorney fees. So again, it comes back to your letting the court system eat up all your money in these court battles. So, like I said, just when it comes to minor children, a one-page guardianship designation signed in front of a notary is all you need to prevent something like that. Now, this next one is a I don't know if it's a fun one for me, but I think most parents don't actually know this, that the second your child turns 18 and they're no longer in high school, you no longer have any legal rights to any information about them. Uh, like at all, like zero. So if your 18-year-old or 19-year-old goes off to college and they're in a car accident, they're unconscious in an emergency room somewhere, that hospital cannot legally tell you anything about their condition. I think most probably do because they are, your parents, but legally they don't have to tell you anything about their child. You can't authorize any kind of treatment for them, and you have no access to their bank accounts to pay their bills while they're incapacitated. So you're basically a stranger to that child in this situation. So, like I said, that this is another classic thing, and I think it's important because we're right around that graduation time where I would encourage if you have a graduating high school senior in your life, get with an attorney and get these three documents put together. You need your HIPAA authorization, so so the doctor can actually tell you about their medical condition. You need a medical power of attorney so that you can actually make decisions for them, and then you also need a financial power of attorney. So again, you can go and get their bank records and pay their bills and make financial decisions on their behalf. I actually do have this as part of my practice. It's the new grad program. I do this for about $750 because it only takes me a couple hours to do it after speaking to the family. So moving on from our high school grad to now our college grad. Uh, we'll call it early career. This is when you have your first real plan, I would say. You have your first 401k, you have a car, maybe you have a couple bank accounts. So you actually have some assets that you need to be thinking about. The good news is, again, it's not super complicated. You need a basic will, beneficiary designations on all of your accounts, and then a power of attorney so someone can act on your behalf. Um, Presumably, if you've already been in the new grad program, then you already have a medical power of attorney. Those need to be done every 2 years. Those need to be updated. What happens if you don't have this in place? Let's say you are a 28-year-old executive. You have a 401k from your first job, and you put your mom as the beneficiary of that. Natural thing to put mom and dad as beneficiaries of your estate at the beginning. 3 years later, that same exec gets married. His wife's pregnant with their first child, and he um, does not update his retirement accounts or any of his bank accounts or anything to put her on as the beneficiary. When he passes, his mom will become the beneficiary of those of that 401k and of those bank accounts because because they have a beneficiary directly on them, they pass outside of probate. So then you're depending on your mom out of the goodness of her heart to take care of your widow and your child at that point. While we would like to think that mom is going to do right by by your wife and her grandchild, that is not always the case. So we don't want to leave that to chance. So that's why I say, get these basic documents in place, and then as soon as you get married, which is our next slide, you need to reevaluate and get all those things updated. Like I said, marriage changes everything legally, but it doesn't automatically update those documents. That's still something that you have to do. You have to go in and change the names on as the beneficiaries, and all those sorts of things. Uh, and I'll go a step forward further and talk about blended families in particular. When you if and when you get divorced, it is crucial that you update those documents because it's not uncommon for an ex-wife to still be listed on a life insurance policy. It happens more than you think. Uh, so when we're looking at these and going through it within 30 days of a major change, marriage, divorce, birth of a child, you need to be thinking about and auditing your estate plan and in particular your beneficiary designations. So let's go back and talk about our kids. We did it a little bit, but let's talk about it a little bit more in depth because when I talk about this is when we bring in the trust aspect. So we talked about the guardianship designation. That is really the control of the person, and I kind of put off what happens to the money. So the trust is how we determine when they get money, how they get money, all those good things. So when you're thinking about how you give a child, in particularly, or just a young person in general, money, do you want to give that to them all outright? Like, what would you do? Think back to when you were 18, early 20s. What would you do if you had automatically inherited $400,000, $500,000? Would you have been financially responsible enough to manage that? I certainly wasn't. I don't think most 18-year-olds are, right? So we don't want them to be in a position where they have all these people in their ears influencing them, and they go and buy expensive cars and just waste money. So that trust is the instrument that we use to then manage those assets for them to control that. So we can do it by age, we can do it by milestone. So if you're doing it by age, you might say, you get a certain amount at 25, a certain amount at 30, 40, that sort of thing. You could also do it like if you go to grad school or if you go to college, you get a certain amount. If you go to grad school, you get a certain amount. So there's lots of different ways that we can make those distributions. You can really tailor that to what you want to do in your family. The next big jump we have is when you start to own real estate. Now, this matters because what controls who gets your real estate is really the title. Um, I think most people assume that if you are a married couple, then your husband or wife will automatically get your real estate when you die. Granted, Texas is a community property state, but if there is not survivorship language in that title, then your portion of the estate will go into probate. They still get to keep their half, but your portion will follow the lines of intestacy if you don't have a will, or it'll follow whatever your will says. So don't we can't assume that even if you are on title that you automatically receive the entire estate because like I said, it has to include that survivorship language. Um, this is what probate is usually the biggest fight is about real estate. Um, what generally happens is, well, there's kind of two cases that happen. You can have grandma and granddad, they pass. No one wants the property. No one takes care of the property. And so it's years before it's probated, or, basically we allow like county taxes to build up. And then it becomes a crucial point where you're facing foreclosure on that property. And then you have to probate it. Um, or it could be that sibling rivalry that we talked about before, where one sibling wants to sell the property, one sibling wants to keep the property, and so you end up in court again in that situation. Neither one of those situations are favorable for keeping the family unity going. So again, we want to make sure that you are titling your property to a trust. There are a couple ways you could do that: transfer on death deed, a ladybird deed. It really kind of depends on you know what your circumstances are at the time. Again, because you have that trust, you're going to avoid probate. and everything is handled by your attorney. Doesn't have to be the same attorney that wrote your estate plan, but it can be handled in-house, an attorney. So once you kind of have the basics, this is when this next step is growing your wealth. You're thinking about asset protection at this point. There's two ways that we can think about asset protection. We're thinking about it both for yourself and then also for the beneficiaries of your trust. And I say the beneficiaries of your trust because if you have real estate, you need a trust. That's just the beginning and end of it. So it's even within the trust, particularly if you are a business owner, you will need to have your LLC set up properly. You need to have maybe a holding company. So you need to make sure that all of your organizational documents are in order. I think that I actually talk about this in the next slide. I do. But just know that as your wealth grows and as you um, gather more assets, you need to reevaluate your estate plan at every single moment. With our firm, we do an automatic review every 3 years, just to make sure that everything is still the way you want it to be. See if you sold any assets or gained any assets, and make sure everything is just properly structured. Again, like I was saying with the business owners, family business is usually pretty easy to deal with because it's going to stay in the family. But you need to have some sort of cessation plan, right? You need to figure out if you were in a car accident and were incapacitated for 30 or 60 days, can your business go without you? Who takes control of that? Um, do you have buy-sell agreements? Do you have all of these in your operational agreements? Does it dictate uh, whether or not the your partner can sell your or buy your portion of the company from your family? Is there a mandated buyout clause? Again, who takes control of everything? Do you even if you don't die, you still need some sort of plan that lets you know what your exit is from the business altogether. Again, um, I think the other thing too is like we call them key man policies. So it's basically a life insurance policy. Having that in cooperation with your LLC and your trust and these partnership agreements can solve a lot of that conflict that comes up when you're dealing with partnerships and family and grief and all those things. So that's very specific to my business owners, but it's also very important. This next piece I'm calling pre-retirement. It's really this is when most people come and see me, right? Um, this is when you're in your 50s, you're starting to think about retirement. You might have some health things coming up, but nothing catastrophic yet. So I think you want to make sure again that you have all of your documents in place, but then we also start thinking about long-term care. And I'll talk about this a little bit more on the next slide when we talk about Medicaid in particular. But this is really when you want to start having those conversations with your children about what assets you have, what they're going to inherit or not inherit, how you want to be buried, all those sorts of things. Retirement. This is when things really start to simplify. This is when a lot of people really start thinking about what their income is going to look like when they are now that they're retired. How do you manage your 401k income, any life insurance that you're using to supplement that? You're probably starting to sell off real estate or you know repackage it and things like that. You're also thinking about again asset protection when it comes to long-term care. Let's just go ahead and go there. So this is kind of the other one, the other milestone that really is crucial. I did at the beginning at the when you turn 18, you lose control. I've had less than a handful of people come to me when they're at a point to where Medicaid is I guess at the forefront, really kind of it's too late by the time you get to me about Medicaid planning, because Medicaid has a 5-year look back. So if you think you're going to need Medicaid, or if you're at a point that you do need Medicaid, you're already too late to do this planning. But because you're on this call with me now, you know that in those late 50s, early 60s, you need to be thinking about an irrevocable trust. What an irrevocable trust is, it actually gets all those assets that you put in that irrevocable trust are no longer under your control at all. What we've talked about up until now is a revocable living trust. That means you are the grantor and the beneficiary. In an irrevocable trust, you are neither you are the grantor. You don't have to be, but you are the grantor, but you are not the beneficiary. You are not the trustee. You have zero control over anything that you put in that. The good thing about that is it's also not part of your estate. So when Medicaid is calculating how much money you have in your estate, they don't count those things in their 5-year look back. Um, it also helps you qualify. Medicaid is it's quite strict. So you can only have $2,000 worth of assets. If you have a house, if you have, I mean, most of us, if you have a bank account, you have $2,000 worth of assets. And Medicare and Medicaid will actually make you spend all of that money down, all of your own money down, before you can allow Medicaid to pay for it. And here's the other thing that we're thinking about when we're talking about long-term planning. The average cost of like a live-in care facility is $70,000 a year. Medicaid won't pay for that until you are destitute. Like I said, you can't have any assets. They will use all of your money. So all of your Social Security money, anything that the family is giving you, all of that will go to paying for your care before Medicaid will step in. If you have memory care issues like dementia, it can be upwards of $90,000, $120,000 a year for that long-term care that you will be responsible for because Medicaid doesn't cover it. And if Medicaid does cover it, they will do that 5-year look back and come and get your money when you die, unfortunately. And how do they get the money? They will actually put a lien on your house, on your property. So you want that property to not be a part of your estate whatsoever. So we're getting to the end now. So I'll just go over some common estate planning mistakes. Hear a lot of people say, I have a will, I'm okay. Um, I'll reiterate this. Having a will does not help you avoid probate. It just, again, it's instructions to the court. It's a public process, so anybody can know what you have in your estate, and it can be very expensive. An outdated plan, again, every 2 to 3 years, you need to be evaluating your plan, and to make sure everything that you've accounted for, marriages, divorces, children, new assets, all those sorts of things. One of the biggest issues I see with most people's estate plans is there's no plan for incapacity. There's no power of attorney. There's no one that can act for them, either medically or financially. Again, estate planning is not just about death. It's what happens to you if you get into an accident and you can't act on your behalf. That it has to be a crucial part of your estate planning. The other thing is, I said on my last call, and I said again, I personally don't have any problems with LegalZoom or wills and trusts, all those automatic internet companies. I will say be careful because they are generic plans. They are not specifically tailored to you. How they go wrong a lot of times, I know of one where the will was valid, it had everything in it, but no one asked him if he had a business, right? So this guy had two different businesses, one with his wife, one with a friend or a cousin. And so those business assets still had to go through probate because they weren't accounted for in the will because there wasn't a physical human person asking him, are there any other assets that we haven't talked about? Do you own a business? All those sorts of things. So just be careful when you use a template. Make sure that you know what the legal requirements for it to be a valid will, a valid trust, and that you're abiding by those things. Because as I said in the very beginning, if it doesn't meet all the criteria to be valid, you don't have a will at all, and you will still go through probate. And in that case, you'll be intestate, And so the Texas laws will determine, or whatever state you're in will determine how your assets proceed after you pass. So this is what you actually need for a complete plan. A last will and testament, we call that a pour over will, when you have a trust, your revocable living trust, and in some cases, an irrevocable trust. It just depends on how much assets you have. You also need your financial power of attorney, so someone could act for you on with banks and paying your bills and that sort of thing. And then your medical power of attorney and your HIPAA authorizations. So that allows them to get information about your conditions and also make decisions for you medically. So as we wrap up here, um, really the call to action is, do you know where your plan is? Do you have a will? Do you have a trust? Is it time to reevaluate that? Feel free, scan the QR code, reach out to me directly, take a screenshot of this so you know how to get in touch with me. Our process is very straightforward. It's personalized. We do a lot of talking in the beginning, so there are fewer mistakes in the end. There are multiple review processes throughout the planning and design of your estate plan. But please reach out to me. Let's have a consult. Let's have a conversation and see where you are and what you need to do. And finally, as a thank you to you guys, I have put together a checklist of essential estate documents that you need to put together. It's everything from driver's licenses to marriage certificates, birth certificates, death certificates, all those sorts of things. So scan that QR code, again, take a screenshot so you can get access to that. And I think that wraps it up for me, Vanda. Happy to answer questions at this point.
Thank you, thank you. This last one, it goes to essentials of estate planning.
Yes.
Okay, essentials document. Okay,
Yep. You need to fill out your name and an email address, I think, and then once you submit that, it gets sent right to you.
okay, cool. I think the only question I saw in the chat was from Tony. He was I think asking about a number that you had mentioned, 30K or 30 million. I was asking if that was for Prince or James.
Oh, that was James Brown. Yeah. Well, both. The James Brown situation, um, basically what happened was the court invalidated his charitable clause in his will. And so that ended up just going to the family. But in Prince's case, there were so many people that claimed to be heirs that they went through a whole, so you have to do a whole family tree when you're doing your estate plan. And so even if you're like a distant cousin, because he had no will, even if your percentage or your fraction of the estate is 132nd, you would still get that 132nd. And of $156 million, 132nd is still a pretty significant piece. And so there were just a lot of people that could lay claim to his estate because he didn't have a will. And so it went down, I think it was like four generations um, of people that got to claim from Prince. And so there's a lot of people that took money from that state. So it ended up being not a whole lot. Basically, it was just his. So they had to actually sell his catalog, and so they do get perpetual payments from that as well. But yeah, that's
Mm,
definitely
mm,
one of the more complicated ones that I've seen.
mm, mm, mm. Okay.
What else you guys got for me? I
Well,
think
I
we're
just
stuck.
want to say that I think that was an excellent presentation because you touched on a lot of big topics, but you really broke it down where like you made it make sense. And I'm also a licensed insurance broker with a designation with long-term care. And you are exactly correct. And that's the biggest thing we talk about with Medicaid compliant annuities. So you can protect your assets because, if grandpa and grandma fall and break her hip, somebody got to go to their nursing home. And if they don't have a plan in place, It's real ugly. So I appreciate you speaking on it.
Well, thank you.
So where do the elderly people go once they've spent all their money and they can't afford these nice facilities?
Yeah, there are state programs or state houses that it's a limited number of beds, and there are nursing homes and rehab centers that will take them. But again, the government decides how much that bed is worth, right? And they pay that. So if you want, you hear the horror stories about that situation. Like I was lucky enough to have my mom and my grandparents go to a facility that we paid for, but when you do that, it's expensive, right? Like for my mom, we were paying out of pocket on top of what Medicaid covered. I think it was about $4,500 a month. And then for my grandfather, um, he had his like VA stuff, but we were still paying. I think my dad said something around like 11,000 was his bill. I don't know how much of that we paid, but the facility that he was at, if we were paying that out of pocket, it would have been $11,000 a month. So it can be expensive.
What should we be teaching our kids and grandkids to start making this a norm? And should we have a meeting with family members to
100%. I think the family meeting is very, very important, right? So many people don't like to talk about death and money in general, because especially in our community, they're like, why would we manifest death? Why would we manifest that and bring it on? But that's not what estate planning is. Think of it as a gift to those that you leave behind, because then they don't have to be worried about it in their grief. They can just grieve and move on. So I think the family meeting is very important, because it also gives you that layer of transparency, right? Like if one of the kids is not acting right and not doing what they're supposed to do, then you can be transparent and open about that and be like, hey, we're not going to give you this money because we've seen how you've acted. Or if you be open about starting a business. Not everybody's made for college, right? So it doesn't have to be go to college, but it can be, you can set some definite milestones about how they inherit and when they can use that money. And I think it's also important for your kids to know how much you're worth. I'm probably a minority when it comes to that, but I think it's important to know that you worked hard for your money, and you are 100% in charge of who it goes to and how it goes to them. It, unfortunately, I think we are living in a time where we have a lot of entitled people, not just kids, adults too. And so I think it's important for people to not assume or feel entitled to your money, because they're not. You worked hard for it. You get to decide where it goes. If you want that reverse mortgage to supplement your income, get that reverse mortgage, and on those sorts of things. So yeah, teach your kids about money in general. Uh, but when we were talking about estate planning, teach them these words, have a vocabulary around it. Because what can happen is if mom and dad have a significant estate, then that takes your kids out of the commercial banking world, right? Banking world. Why don't mom and dad finance that son's house for his marriage, right? Instead of having to go out and get a 7% interest rate, you can give them a 2% interest rate. Have the trust be the bank. When we're talking about generational wealth, let's really make it generational wealth. Your kids and your grandkids don't have to
I
start
tried it.
over.
I like that.
No, I
So
I have a
great.
question. How much like does a trust to establish a husband and wife trust? Like how much you said the kids is like 750. How much is it with the adults?
Okay, every attorney is different. I do not do hourly
Oh,
billing.
okay.
I do flat fee billing. A base trust, just like a single person trust, starts at 3,500 for me. I
Okay.
don't know where I fall. I'm sure there are some that are less expensive. I know there are some that are way more expensive than me.
Yeah.
So I call around. Most people won't give you a like a price over the phone, and that, like I said, that's a base. Really depends on what you want to do in the trust, whether or not we're doing some sort of, asset protection type deal, whether or not we're doing sub trust for the kids or grandkids, whether or not we're doing, if we have business succession planning in that. Those are all different tiers. And if
But you
even if
can
your
put it
husband and wife are
all
doing it,
under.
if you're doing a joint trust versus two separate trusts, those are two separate prices. So it's a range.
Okay.
The most expensive one I've ever done is 6,500. And the least expensive one I said is, when I first started, before I realized how much time this was going to take, I was undervaluing myself. So my least expensive trust was 2,500. But yeah, my most expensive to date is 6,500.
So you could put it all under your house, life insurance, business.
Everything. Like I encourage people because they usually will pass on property that still has a mortgage on it. So either fund insurance policy that the house is completely paid off, or put some
Hmm.
funds in the trust so that you have some time to figure out what you want to do with the house. 6 months, 9 months worth of carrying costs for the house. So you're not dealing with that immediately when you're in a grieving period, right? You have a little bit of time to figure out whether or not you want to keep the house. If you're going to keep the house, how are you going to keep the house, or if you want to sell it. So yeah,
Hmm.
it's not complicated, but it can be complex depending on what you want to do.
Hmm.
So when you write a will, you have to, what's the process? Because I've heard different things, but so you need to write it, get it notarized, and then have it filed down in Dane County. I mean, I'm sorry, Bear County.
You don't necessarily have to file it, but somebody needs to know where it's at. I actually will try not to. I encourage people not to file it actually, because if you move, like if you end up in a different county, it has to be filed in the county that is your last county of residence, right? So if you file something in Bear County and then move, I don't know, two counties over, then you're actually going to be filing your probate two counties over, and you have to pay to get it taken from Bear. Like, so it's complicated. I would rather you just have it
Oh,
somewhere around the
wow.
house, than file it with the court necessarily, unless you just know for sure you're not moving. um, and most attorneys these days will keep a digital copy somewhere. So I always give the originals back to um, to the client, and then I keep a digital copy on hand. So for some reason, if it's lost, then we always have that to fall back on.
Hmm.
And my last question, I'm sorry. But okay,
Go
you
ahead.
always see it in movies when somebody, that's famous or popular, got a lot of money, and then they call the family in and there's someone there reading off the will, right? So is that
Yeah,
the executor? And how do you know?
there's
Okay, if I had you
that's
as
for the
my
movies.
attorney, that's
Yeah,
okay, okay.
that's for the movies. Usually, there's like most times it's the oldest daughter that knows where everything is, right? And she's probably named the executor.
Okay.
She will hire an attorney, and that attorney will handle everything. There may be like a reading of the trust, perhaps, but yeah, the reading of the will is something that's for movies. Because how do you, like you said, how do you know that you're the executor? You have to go through the probate process to know who that person is. So there can't be a reading of the will because we don't know what all the assets are at that point anyway. But yeah,
Okay. Thank you for clearing that up because
I,
I was
I do
confused.
I have a service that I work with where you basically the client can tell family stories, and we can have a collection of writings and video of that person that's left behind. So one thing that I quickly realized when my mom passed was that I missed the sound of her voice. And so little things like that I try to do as a benefit or an extra for my clients to have your face and your voice recorded for prosperity, telling telling stories or just sharing life lessons that you want to share. So that's another part of what I do for long-term clients, that my aftercare program basically. So
It's powerful.
So can a will be a verbal?
it cannot be verbal. It has to be written, either 100% handwritten, and then like I said, signed, notarized with two witnesses. Even one that's typewritten needs to be have two witnesses. If not, there are a few more hoops that you have to jump through to prove that it's valid. Uh, but yeah, everything needs to be in writing. There cannot be a conversation that you had with that person. Great that you have the conversation, but if it's not in writing, it's not legal.
That was something I saw in a movie too, Tiffany. That guy had recorded, his last will. So he was overriding the written will and saying, this is what I
Mm.
want.
No,
She was like, nah, we don't
nope.
do it like
It
that.
won't override it, but it won't override a writing. It may be, I guess, decent evidence if you're trying to contest something, but it won't automatically override the writing.
Okay. Anybody else have any questions? I knew
Awesome,
you
guys.
had
Well,
one, Jerry.
Girl, I got
if
so
Gary was on
I
our
got
last
so
call,
much. Yeah, I'm gonna have to get with Shema. We're gonna have to get together soon because time is ticking on. I said that before and I never moved forward, but I need to move forward because it's my dad's not getting any younger and that stuff is crazy with his stuff because he's that will he has says nothing and he's in the country and so that lawyer just took his money because she really didn't it doesn't say any for me it doesn't say anything it doesn't
I got you.
clarify anything it's not straightforward nothing's in it so and he has real estate so there needs to be and I keep telling him that he needs to get a trust and get that sorted out before something happens to him and then he has me like right now he has me the executor over everything so then it's going to be I already see the issues especially with one of the siblings so I keep telling him you need to straighten that out because I don't want to have to cut him so it's like it's not that
Yeah,
crucial.
we don't need you ended up in jail
Yeah,
after all.
exactly. But yeah, I keep telling him that every day. I said we need to do it, but I really need to get with you, Shima, so we can get that started. I talked to him about it, and he's willing, but I just need to set it up.
All right.
Take my laptop down to the country and
I was
have a
going to say, if
Zoom
you did the last
call.
call, we
And
can work that out too.
yes, yes.
Well, I appreciate y'all's time. And again, you have all of my contact information. So if anything comes up, just hit me up.
Thank you very much.
Thank you so
Thank you
much.
so much.
Bye, you guys. Have a good
Have a
evening.
blessed evening. Bye.